Mr. Chairman, we are live.
All right, welcome to Friday and the House Judiciary Committee meeting. We've got two bills in front of us today. One of which we've been trying to get to for a little bit, Senate File 75 and then Senate File 66. And I feel really good about the possibility of getting through both of these bills this morning. I feel really good about that, committee. Kay, will you please call the roll?
Yes. Representative Crago. Here. Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Excused.
Representative Williams. Here. Vice Chairman Washut.
Excused.
Excused. Representative Yin.
Here.
Representative Swanitzer.
Here.
Chairman Olson.
Here.
Mr. Chairman, you have 7 in attendance, 2 excused.
All right, Senator Landon, come on up. You brought your counsel with you.
Mr. Chairman, I thought there's no sense in anybody sitting way back there. You know, she might as well come up here. Mr. Chairman, thanks for the opportunity. And I really have actually enjoyed the week. Appreciate the work you guys do. And this is always a tough section of our laws. And so I'm grateful to have those who practice in the legal profession to help us navigate these things. And I will say up front that I'm not of the legal profession. But I do like to always start when I have a bill like this. I like to give you a little sense of the genesis of the bill, because I love the fact that we are citizen legislators, and I love the way that works. And I've got a very good friend who does practice law, or did, and we made him a judge. And not long ago, I ran into the judge up in Casper, and we were having a good visit. And he knew that about 4 years ago, I had worked very closely with a dedicated group in Casper that had taken on the stalking laws. And we very definitely had some holes in those laws. And we went to work on it. And I brought a pretty comprehensive bill, and it came to the Judiciary Committee in the Senate, and hit a brick wall the very first day, and down it went. We stayed with it. It went to an interim committee, and they worked it. Your Judiciary Committee worked very hard on that, and we gained some really good ground. Well, this good friend of mine in Casper said you might want to be aware of a case that happened in Sweetwater County. We had a case where a felony stalking order was thrown out because a stipulated order was in place in the beginning. And so I think we can talk a lot more about that today if you'd like, but I think what that did, representatives, is it threw some confusion and certainly threw some inconsistency into the mix. And so that's the genesis of Senate File 75. Mr. Chairman, I've got some kind of prepared remarks, and then I'd be happy to visit about the bill. One thing about my travels with this bill, I've learned that these protection orders, and specifically stalking, sexual assault, domestic violence protective orders, must be viewed and treated like all valid orders of the court. This bill does a couple of things, representatives. First, it allows the parties to protection orders to make knowing and voluntary stipulations to the order and allow the court to have jurisdiction. This saves the court time. It allows our victims to not have to face their stalker abuser at the height of the crisis. And it allows the respondents to not have this impact other open criminal charges at the time of the stipulation. And then second, it ensures that this order is valid and enforceable, just like any other stipulated order in a civil or criminal court. So if you go to the bill itself, you will see that in 73509, which relates to stalking and sexual assault, we've added the clarifying language there. That language continues over onto page 2, where it is followed by 3521-105, which is the domestic violence protection orders. And we've added the identical clarifying language there. A respondent may make a knowing and voluntary stipulation that a court may exercise jurisdiction over the respondent and issue an order pursuant to this section without a hearing, factual finding, or admission that the conduct giving rise to the petition occurred. Some Wyoming attorneys who work in these protection orders every day, and to ensure protection orders aren't treated differently than any other court order suggested, we needed one more sentence. And that's where, Mr. Chairman, the Judiciary Committee on the other side stepped in. And we added the language in both of those sections. An order made pursuant to this section shall be valid and enforceable and have the same force and effect as a protective order entered with findings of fact and conclusions of law. The reason I think that the Judiciary Committee added that language was to go back to the case in question, which was the genesis of the bill. Mr. Chairman, much more that we can talk about this morning. That's a quick rundown on the bill. We have several, I think, who are the experts in this field. And so I'll step out of the way and let you get to some of the testimony this morning. Be glad to answer any questions.
Questions for Senator Landon? All right. Attorney Generals.
Chairman Kara Chambers, Attorney General's Office, Division of Victim Services. Really mostly here to answer any questions that may come up. Our office's involvement is that we're statutorily required to develop the form along with the Supreme Court. And so we will make any necessary changes. We really felt it was important to clarify the enforceability of a stipulated order. We didn't think that should come into question, but it did. And so really that's just doing this, just adding that very clear, full force and effective law language. If you've ever looked at, and unless you're a lawyer, I hope you haven't seen a protection order form, but there are literally boxes that the judges check, and it right now has the stipulated language in it. But apparently there was some confusion across the circuits, or the districts rather. So this is really a cleanup, a clarifying. We think it's important for victim safety. It's important to note that when you can get a stipulated order, it's really best for all parties because you're kind of tamping down that animosity and that controversy and just, really allaying any of that unnecessary strife. So with that, I would really just stand for sit for any questions that you may have about this.
Thank you, Mr. Chairman. And so I really apologize. I'm just not getting it. So if you could explain to me, like I was a junior high student, what the bill does and why it's important and what the loophole is at a very basic level, I'd be appreciative.
Ms. Chambers.
Chairman Olson, Representative Swanitzer. I will talk like you're my 13-year-old daughter.
I was going to say that.
No,
I didn't want to be rude. So.
You're fine.
Talk to me like I'm
This is really a signal to the judiciary, quite frankly, where there was some differing opinions, I guess is the best way to say it. So this is making it crystal clear that, the provisions we already allow that you may have a stipulated order doesn't change the enforceability of the order. And so we're spelling it out by saying,
Mr. Chairman.
Yeah.
Can we go back another step to elementary school? What is a stipulated order? I'm sorry.
Chairman Olson, I apologize.
Yeah, no, I think it is a good question
Yes.
because I think what you're, I think because you're talking about the differing opinion in the judiciary
Sure.
versus an order that the court issues, right? Versus the parties stipulate and the judge still signs the order. And then so maybe kind of walk through
Sure.
that scenario.
So Chairman Olson represents the wanted, sir. So when a victim, because again, we have three types of protection orders: sexual assault, stalking, and domestic violence. And so this is across the board for all three. When a victim petitions for a protection order, they will petition for pro se and they'll get an order. And then the offender will be served. Pro se means without an attorney of their own accord. Sorry, I'll step it down. I know how smart you are though, so. And then they'll go in front of, when the respondent is served, they'll have into court, you can have a hearing where both sides would present evidence and you can have an order entered that way. And on the form, that's a different box that you would check. Or you could have the opportunity for the respondent to stipulate, yes, I'm not saying I did it, but I'm saying I will respect this order being entered. And that's why we think it's so important to tamp down that animosity. It's just sort of saying, all right, you don't have to admit to guilt. You don't have to admit the underlying sexual assault, stalking, or domestic violence, which, as Senator Landon mentioned, could come into play in other proceedings. But acknowledging that, okay, right, you can have this order. I acknowledge all the, items in the order that I should stay away and et cetera, whichever boxes are checked. So stipulated, really just saying, yes, we agree this order should go into effect without any findings of fact or conclusions of law being made. And so this is, yes, and I think.
And yeah, and to kind of dovetail off of that last little piece. And this is very important, I think, because you could stipulate in that order that there was not you don't have to stipulate there was a finding of domestic violence.
Correct.
That's really where the key is, because a finding of domestic violence, if it comes out of one of these hearings, has implications in our custody world versus, and so that, I mean, that's probably why I think a lot of these end up, I would guess, at hearings, is to try to avoid that finding, because and so at least I've had limited experience in this. And then I know some of the lawyers in my office have had more experience with this than I have, but it seems to me like, to your point of reaching stipulation, I know my attorneys strive to reach a stipulation, because if they can get a stipulation without a finding of domestic violence, put the order in place, protect the party, create the separation, but not cause implications in the future custody case that may occur, then everyone kind of comes out of that a winner.
Chairman Olson, I think yes, that's exactly the point. And we really do feel it's best for both parties, or at least that's our understanding.
Yeah, Representative Oakley.
Thank you, Mr. Chair. And to dovetail on that, interestingly enough, you can tell where we come from. So Chairman Olson talked about findings for custody. And the other thing that we deal with this a lot in the criminal law world is, if there was a finding, that means that evidence would have to be put on. And in a lot of domestic violence, there's a current domestic violence charge going on. So it violates their rights. So this is kind of a balance between, so a protection order can go into effect for the victim while not affecting the defendant's rights at having evidence literally put on the record about their case that's ongoing. My question to you, Ms. Chamberson, I read something yesterday, but I'm a little, I don't know, about the necessity for this, because as you said, this is something we've been doing for a long time. This isn't new. I was like, what is this about? We already do this. But then I got an email yesterday or something about I don't know, about the impetus for bringing this. And I think you were saying some judges go, anyway, if you know anything.
Yeah, Chairman Olson, Representative Oakley. Yes, the example that Senator Landon gave was out of Sweetwater County, where I believe, a judge just felt that the order wasn't valid because it was a stipulated order. And so this really is codifying that language to make it crystal clear for anyone who looks at the statute that a stipulated order has the full force and effect of law. And so it's it's not really a solution in search of a problem per se, but it is making sure that we don't have future problems with more than one judge who may have viewed this, in his own discretion one way. It's just to make it very clear and to come into conformity with full faith and credit laws across the nation. And
Senator.
Well, Mr. Chairman and Representative, for me, in the conversation that I had with one of our judges, he indicated this certainly was not a Supreme Court decision of any kind, but he said it was one of our courts, and that finding does create a little bit of confusion out across our courts statewide. And so he, I believe, favors this just because it makes it clear. And it also brings some language in that is already in the stipulated order. It brings that language into law and just reminds our judiciary, this is the expectation. This is what we expect to happen. And you can't, just because you stipulate, you can't go out and reoffend, because our statutes say if you do that, we're going to raise this to a felony level. And so I hope that helps.
Ms. Chambers, Senator, I guess I'm a little curious. This is kind of, so, why it's the issue really at the end of the day is an issue where the judicial branch questions whether a stipulated order is actually an order, which is a little confusing to me. But why not have would that impact other areas of law? I'm just curious, why not have a bill that just says generally a statute in Wyoming that says stipulated orders are, basically this second half that the Senate added on. If you could have a bill that literally covers all areas of law, an order entered, period, even if it's stipulated, has the same force and effect as any other order. Wouldn't that, is there some other area of law that we would strangely impact? And I guess I'm asking that question to point out that this is a very unique scenario where a stipulated order isn't given the full force and effect of as an order.
Chairman Olson, to be very blunt,
I'm ready.
maybe I should just stop there. Never mind. I think you're right. You're right.
I don't
An order
practice
is an
in
order is an
Sweetwater
order.
County, so it's okay for me to, and I also don't really practice in courts, so it's okay it's okay for me to really question what happened here.
You're fine. Well, and of course, you may be aware of, who I live with. So, I have to be very careful as well to not step on the judiciary. But to be very clear, I think there is sort of a little bit of a bias on these type of cases, domestic violence, sexual assault, stalking, that these are made up, that these are frivolous, that they're somehow not worth the same value of any other court order. And I hope that's not truly the case, but I do think that they are viewed under a different lens. Adding this language to the statute then would allow my office and the Supreme Court to coordinate to maybe go back in and tighten up whatever language we need to on the form, so it's abundantly clear to everybody. But you're right. It is creating an interesting. We shouldn't necessarily have to do this, but we do, and we, my office is here to provide information. I don't. But this is what victims. I think you'll hear testimony from other individuals aside from my office. My agency is just saying, if you want the form fixed, we need to do this. It helps us to be able to go in and strengthen up this form so it's abundantly clear that these stipulated protection orders carry the full force and effect of law.
And Ms. Chambers, maybe something we didn't talk about, Senator Landon, as well, and for the non-legal beagles, is how that form is really worked through the system, because lawyers are kind of hands off at that point. Generally, victims have advocates, and so I'm pointing that out, that there's a process where it doesn't get hyper legal, where you have victim services, advocates, third party organizations who help them walk through the stipulation. And do you envision that's I'm trying to figure out how they coordinate the stipulation. I'm guessing, do you envision that our third party advocates are the ones who are going to be sitting down with the respondent,
or so, Mr. Chairman, I'll jump in real quickly, just on a couple of fronts. Appreciate your questions. I would just point out, I did a little bit of homework on this front, and you can enhance these stalking penalties for bail, for probation, for parole, and even ex parte hearings. But if there's any question about that felony charge on a subsequent offense, why wouldn't we want to do this on a stipulated order like this? So, that's one point. Regarding the process, I think we do have Ms. Chambers here and some other professionals who've dealt with it a lot more than I do. And so I would hand that again off to Ms. Chambers. So.
Chairman, an advocate would help with the pro se process. These still come in front of a judge. I do believe we have 2 attorneys from the Wyoming Coalition Against Domestic Violence and Sexual Assault who actually are in court doing these, because I will admit, like you, I am not in court doing these days. And so they would be able to provide you the nuts and bolts of what it looks like on a day-to-day. But yes, a victim would usually come to a victim service program, one of the 62 that my office funds across the state. Again, in the protection order realm, it's usually one of the nonprofit domestic violence sexual assault programs, and they would work with an advocate on the form, and they would get this worked out. Nothing gets started until the respondent gets served, and then it would be a matter of working these out, whether either party has an attorney entering to a stipulated. I will say that just my understanding is that this is the preferred method. It's, again, preferred to have a stipulated order because it ramps down that animosity and is better for all the parties involved. But again, I would just say you probably have some attorney experts who are in the trenches on this who might be able to better walk you through the step-by-step.
Clarissa, do we have anyone in the virtual world wishing to testify on this Senate file?
Mr. Chairman, we do. We have 3 folks with their hand raised. We have Miss Muir, Jean Kaur, and Haley Dunn.
Okay, let's start with Tara. Tara?
Good morning.
Good morning. Welcome. Introduce yourself and let us know your thoughts.
Excellent. Thank you. Didn't know passing through Twilight Zone if someone was actually called on, but I'm Tara Muir. I'm the Public Policy Director with the Wyoming Coalition Against Domestic Violence and Sexual Assault. I'm also an active member of the Wyoming State Bar, and myself, along with Jeannie and Haley, who are joining us today on this call, we all work for our network of crisis programs that Ms. Chambers pointed out. Ours are the nonprofit side. We have very rich confidentiality protections when we work with victims. That's how we're a little bit different than some of the government victim witness unit personnel who might also help people with protection orders. Our programs talk with victims every day, all day, hundreds actually. We are here in support of this Senate File 75. I'm the one who sent the email yesterday that just let you know and had attached the actual case where all of this bubbled up. And I want to thank Senator Landon for taking this on and providing some clarity. I'll just say a couple things and then I'm going to turn it over to my co-workers here. The case that the judge wrote a nice opinion about got cited to a North Carolina case that was just wrong. And I think if you watch the Senate Judiciary Committee talk about this bill, one of the senators said, hey, the judge in our county just got it wrong. And this is just fixing it. And I think that's really how it's best to talk about this bill. It's just fixing this one problem that seems to have ricocheted across the state with some confusion. So the North Carolina folks, once one of their judges tried to say, hey, these orders are second-class citizens, we really don't have to enforce them, they went to their legislature as well and passed the very same pretty close to the same sentences in North Carolina. So when I saw Senator Landon's bill also trying to address this problem, I just wanted to make sure we added the enforceability piece because that can really create more confusion if that's not in there. And Chairman Olson, I agree. This is kind of first year law school basics. But I think we want it in this protection order piece so that protection orders don't get treated like some kind of order that's not serious. And with that, I'll take questions and happy to turn it over to Ms. Kaur and Ms. Dunn.
Excellent. Questions for Ms. Muir? All right. Thank you very much. I'm going to make sure that the presenter of this bill starts off by saying, this is first year law school stuff here, folks. All right, who
It's
wants,
the only way I could carry it, Mr. Chairman.
who wants to go next? All right.
Thank you, committee, Mr. Chairman and representatives. My name is Jeannie Kaur, and I am an attorney with the Wyoming Coalition Against Domestic Violence and Sexual Assault. I represent victims of those crimes in circuit courts around our state in protection order hearings. I wanted to start with a little bit of the nuts and bolts of how protection orders happen and how these stipulations come to be. Wyoming, as you know, has 3 types of protection orders for domestic violence, stalking, and sexual assault. And when a person's been a victim of one of these crimes, they can file for a protection order using those propagated forms from the Supreme Court. And then the court holds an evidentiary hearing to decide whether or not that protection order should be granted. And frequently, the petitioner, that person that was the victim, and the respondent, the person that was the perpetrator, will come to an agreement that allows the order to be entered without having that evidentiary hearing. The order is granted without the court having determined whether an act of domestic violence or sexual assault or stalking has occurred. And this is called a stipulation. And it's much like another out-of-court settlement in other kinds of civil cases or a plea agreement in a criminal case. The advantage of a stipulation to the victim is that they don't have to go through the trauma of testifying in front of their abuser in court. This is especially important when the victim is a minor. And they still can have those safety protections that are the reason they filed that order in the first place. There are also advantages of stipulating to the respondent. We've talked a little bit about what those could be in a criminal context or in a family law context, because though protection orders are civil orders without criminal penalties, and there's not a decision of guilt or innocence, there are often accompanying criminal cases that are happening at the same time, and having evidence put on the record, both for the victim and for the perpetrator, can have impacts on that criminal case. There are also frequently domestic relations cases going at the same time, and a finding of domestic violence or sexual assault or stalking can have an impact on those district court family relations cases. Stipulations are voluntary for both the petitioner and the respondent. The parties are always entitled to have that evidentiary hearing if they don't want to agree to a stipulation. And in an evidentiary hearing, the judge would determine, after hearing the evidence, testimony, whether or not that act of domestic violence, sexual assault, or stalking has occurred. And because respondents have this opportunity for a hearing and they voluntarily elect to waive that right, their due process rights are protected. Now, most circuit courts around Wyoming are entering stipulated orders in these cases. During the years of my practice, I would say 3 out of 4 of the cases that I'm working on end in a stipulation. But there's nothing in our current statute that specifically authorizes them. There's nothing that prohibits them, but nothing that authorizes them. And this bill would help our protection order statutes reflect what is actually happening in Wyoming circuit courts. Because it's not authorized in statute, some Wyoming courts are now becoming hesitant to enter stipulations, and some question whether they're enforceable. And there are judges who feel they cannot enter an order without a finding in order for it to be enforceable. And this small addition to our existing protection order statute would give clear direction to the court that these orders are permitted and that they are enforceable, just as a regular protection order with a finding would be. I wanted to address specifically the case that kind of brought this to a head. And you have copies of it. It's called State v. Azo Party would be the way I pronounce it. What happened is the respondent consented to a stipulated protection order that was a stalking order, and then violated that stalking protection order by stalking the person again. There is enhanced penalty in our statute that says if you violate a stalking protection order by stalking, then you would have enhanced penalties. And this whole thing happened because the judge decided that because there had been no finding in that stalking protection order that was originally entered, that he wasn't subject to those enhanced penalties. So that's kind of what happened. And so there's been a pretty big ripple effect throughout courts in our state that has come from that finding, that now courts that used to enter stipulated agreements are hesitant to do so, or have asked parties to acknowledge that it might not be enforceable. And it's created a pretty big difference from county to county on how these stipulated orders are either able to be entered or how they are enforced. And asking a couple of questions, how stipulations happen. So if lawyers come on board, which often happens in protection orders, the lawyers often will negotiate a stipulation after these orders have been entered. The other way that stipulations happen is when they come to that evidentiary hearing, the judge will generally ask the parties, do you want a stipulation? And so everyone has access to a stipulation as long as the judiciary knows that it's something that they can enter. And then the last thing that I wanted to address, the same federal law that prevents people who have been convicted of domestic violence or felony convictions applies to some people who are subject to protection orders, and that they are prohibited from possessing firearms. That federal law includes stipulated orders. So what we're doing today has no impact on gun prohibition. Whether you are subject to firearms restrictions in a protection order depends on whether you're classified by the federal law as an intimate partner. It does not depend on whether the order was a stipulated order or not. And with that, I'm open to any questions.
Questions, committee? All right. Thank you.
Thank you.
Okay, I think it is my turn. Thank you, committee chairman
You're up.
and
Yep, you're up.
and representatives. I want to warn you guys, if you do ask me a question, I will probably respond by calling you your honor, and just prepare yourself for that now. As Jeannie and Tara have talked about today.
That could actually impact the vote.
I mean, definitely take it as a compliment, and not that I just forget where I'm at, because it's definitely a compliment. So I was asked to talk just because this has directly impacted multiple of my cases. And fun enough for me, they both happened in the same week in August. So this case, as a party, first came to my attention in August. And in that case, I was trying to get a sexual assault protection order.
Hey, Haley.
Yes.
Oh, sorry. I was just testing to see if you'd call me your honor. But no, can we have you introduce yourself by name just for the record? And then if you're with an organization, we need that for the record as well.
I apologize. My name is Haley Dunn. I am an attorney for the Wyoming Coalition Against Domestic Violence and Sexual Assault, and I am located out of Natrona County.
Thank you. Please proceed.
So in this case, we were doing a sexual assault protection order, and we wanted to come to a stipulation. My client did not want to have to testify. It was very traumatic and what had happened was pretty gruesome, if I'm going to be honest with you. The respondent also did not want this on his record. He had pending criminal charges that were unrelated, or not criminal, but legal issues that were unrelated to our case. And if this finding came, if there was a hearing and it was found that he had committed an act of sexual assault, it would have, for some reason, I don't really know what was going on, completely hurt him legally. So we were very much wanting to come to a stipulation. Luckily, the judge did agree that he could, but he made sure we had a long discussion about this case. And he was like, I don't know if I can do this. I'll let it happen right now, and we'll see what happens down the road. And so far, that case has stood. My next case was not as lucky. This was a stalking order of protection. We came to a stipulation. We went to court to enter the stipulation, and the judge denied our stipulation, said he would not enter the stipulation into the record. This meant that my client had two options: pretty much drop this order or testify. She did not want to testify. She was terrified of this man. She did not want to have to deal with it. When you work with victims of trauma, this is common. They don't want to have to go in front of a court. For me, going in front of court makes me have anxiety, and it's my job. So for someone that doesn't have to do it, it's even worse. And that's definitely why we want these stipulations. Let me see what other notes I had. One of the things that one of you guys asked was, do third-party advocates enter stipulations? I will let you know from my experience that does not happen. I do work in one of these programs, or my office is located in one of these programs, so I work very closely with them, and they will help with the drafting and all of that. But once it gets past just drafting these initial documents, they don't participate too much, because that would then put them in the category of practicing law. And so they try to make a strong line where that is. So they do not help with the stipulations. If there are stipulations, it's either the judge asking, as Jeannie said, or the attorneys or the clients just coming together and coming up with something. I think that is all I have. So if you have any questions for me and want to be called your honor, I am all yours.
Questions, Representative Yin, for Ms. Dunn.
I have no questions, Mr. Chairman. I like the bill.
All right. Wouldn't you agree? Then it's a question.
Your Honor, yes.
You agree?
All right. Thank you, Ms. Dunn.
Thank you.
Clarissa, any other hands come up in the virtual world?
Mr. Chairman, I don't see anyone else who is online.
Oh, okay. Well, thank you for your virtual testimony today. Senator Landon, any closing remarks before we begin the vigorous debate amongst the committee on this bill?
Thank you, Mr. Chairman. Again, I appreciate the committee taking up the bill. Really appreciate those you've heard from this morning. Them jumping in behind the effort has been very helpful. I'm not going to belabor. I really admire the work that those of you who practice law do in this part of the world. It's a very difficult thing, as was alluded to on the screen. I've come to know, for many years, I was in the Dean of Students office at the college in my community, and ran across situations where I'm not sure we have these protective orders right, even now. I mean, I'm sure there's ongoing efforts that we're going to have to stay diligent. But at the risk of sounding a little bit overly dramatic, Mr. Chairman, I think these are the kind of bills that can save somebody from a lot of anguish and maybe even save a life. So I'm proud to bring the bill. It was well received on the other side, and I hope you can support it. Thank you.
All right. Close public comment on this bill. Committee, what is your pleasure? Moved by Representative Oakley and seconded by Representative Williams. Any amendments on Senate File 75? Question being called on Senate File 75. We really could have made this effective immediately, but. Okay. Yeah.
Thank you, Mr. Chair. I just want to say very briefly, a yes vote. Again, this is something that is currently, has been in practice. But just briefly, I guess maybe possibly to understand some of the issues, I would disagree that with the classification that if like judges don't believe that this is correct or something, that it's because victims are considered second-class citizens. I understand advocacy. I don't think that that's necessarily a fair, the idea, and I said it earlier, but there is, I mean, the defendant or the person that's on the other side of it does have some rights. And when you're talking about a stipulated order, at least temporarily, it can affect their gun rights. It can affect their freedom of movement. Having a protection order against you can be significant. But the reason I'm okay with it, trusting our judiciary to do what's right, it does say that it should be a knowing and voluntary stipulation, so waiver of those rights. But so that, because what it does do is without findings of wrongdoing, it affects some significant rights. On balance, I think this works. But I just want to say, I don't think that, you know, judges or people or law enforcement or anybody's ignoring it because of not being, you know, trying to help a victim or an alleged victim. So, but with that, I'm certainly for the bill.
Representative Crago.
Mr. Chairman, actually, if I could propose an amendment to change the effective date to immediately rather than July 1st, would so move.
And seconded. I don't think the Senate won't have an issue concurring with that. I think you'll work. All right. All those in favor signify by raising your hand. All those opposed, that amendment carries. All right, question being called on the bill. Katie, you got that amendment? Will you please call the roll on Senate File 75 Protection Orders Amendments?
Representative Crago. Aye. Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Did she leave a vote sheet by chance?
She did not.
Excused.
So I'm sorry.
Excused.
Okay, thank you. Representative Williams.
Aye.
Vice Chairman Washut voted aye.
Okay.
Representative Yen.
Aye.
Representative Swanitzer.
Aye.
Chairman Olson.
Aye.
Mr. Chairman, you have 8 ayes and 1 excused.
All right. Thank you, Senator Landon. You have on, I've been in discussions with Representative Brown, your co-sponsor on it, who I believe does want to present this bill on the floor, but it sounds like you'll have a lot of support from the judiciary.
Thank you, Mr. Chairman. Really appreciate the opportunity to visit about the bill. And thank you. That's one good thing about crossover week is I finally get to see all of you. So thanks for all the work you've been doing.
Thank you. Senator Cooper, welcome to the House Judiciary Committee. Brought us a good little bill here, Senate File 66. Please walk us through your bill.
Thank you, Mr. Chair. Committee. SF 66, Clare's rule applied to joint ownership to talk to you just for a second about the origins of this bill and some of the testimony we heard. The origin of it was based on a family that came to us with an issue of their daughter. This is based on his testimony. Was murdered about a little over a year ago in a town north of here. The husband came home from work. They had no children. That's part of the issue here. The husband came home from work, and for whatever reason, put her down on her knees, shot her with her hands behind her head, shot her 5 times. Through the course of the night, he killed all the family pets. And then towards morning, with his wife laying there on the floor all night, killed himself. Since that time, the family has been trying to recover their daughter's possessions. But in Wyoming, because everything they held was joint tenancy was right of survivorship, and she died first, all of her possessions belonged to him. And then when he died, all of his possessions belonged to his family. And the family in Orland or in the north is just trying to get their possessions back, their daughter's possessions back. And they just continually run into roadblocks in the court system because there's no method to do that. When we first started looking into it, it was pretty simple. Well, Slayer's rule applies. You cannot profit from the death of another. But when we put this together in Wyoming all those years ago, I'm sure nobody considered the fact that this was the possibility. So looking into it, we found that not only is it that rare, it's actually pretty common. We've found a lot of testimony that this is happening. One person right here in this building testified that it happened to his family and 10 years ago, and there was a child involved, and that husband is still in jail, and they still have not recovered the possessions. So with that said, that's the purpose of the bill. That's the testimony we've heard, and it's pretty heart-wrenching to listen to it. So what we've done here on page 2, lines 4 to 6, simply changes the numbering. Line 7 through 10 addresses just that. You shall not inherit, receive, or otherwise take property held as a deceased in joint tenancy, right or survivorship, tenancy entirety, or other co-ownership that's right or survivorship. We've added some language to it. You shall not inherit, receive, or otherwise take any property conveyed by the deceased person by beneficiary. Transfer on death designation, payable on death. So this addresses the IRAs, the things of that nature. And then we went on to address the insurance issues. If that person is a beneficiary of a policy, he or she cannot receive that distribution. If there is a distribution to other families, that's part of it. But for this purpose, the person, if they both die together, the person causing the death of the deceased is treated as he's predeceased. In other words, he died first, and the person who that he killed would actually inherit his things. So it reverses the inheritance on it. So that's the bill. That's the purpose of it. I'm afraid I don't do a very good job of explaining it. I get a little bit tongue-tied when I think about the situation that these people went through. It was pretty heart-wrenching. In the case of the member in the Capitol here, the family fought hard to get the father stripped of his parental rights, and were able to get the child back and adopt the child, but they have not been able to even get their the daughter's possessions back. So it is a problem. It's a problem that it's easily solved, and I ask for your consideration.
Thank you, Senator Cooper. My question is, because I don't deal in criminal law, I deal in estate law, so everything else makes sense to me. My question, and this might actually be for Representative Oakley, just to the top of page 2, when we say no person who feloniously takes, causes, or procures another to take the life of another person, when we say felonious, does that mean that there has to be a criminal conviction, or it just has to meet or we're saying if we met all the elements of what would have been a felony murder, then help me with that, Representative Oakley?
Thank you, Mr. Chair. I probably should have parsed it out earlier, because when I saw this bill first months ago, I thought of that, and it seems like I rectified it in my mind at the time, and now I can't, because especially like looking at the instance that was used in this case, clearly he wouldn't be convicted of a felony, right? We don't go prosecute. So that does leave the question, and this is where the intersection of civil and criminal, and then that I would then defer back to you. Is there a procedure in criminal law under which it could be found? I mean, the conduct, we would all agree, would clearly be felonious, but the person would not be convicted of one.
Right. So I feel like if I'm trying to work through what this would look like, if I'm challenging the inheritance and I'm going to use the Slayer rule, then I think I have to first prove that that a life was taken, and that a life was taken feloniously. And then the rest of then of course, as long as I think proving the joint ownership is probably the easiest part. Well, that's the last part. I prove that there's a joint ownership at stake. But I think the heavier burden is that I've got to prove that I think that it was felonious. That's what I'm trying to figure out. That a life was taken, that's easy. Okay, here's a death record, a life was taken. What I'm trying to figure out is what I would have to prove as the lawyer challenging the inheritance. So I'm trying to preclude the inheritance from occurring felonious. And maybe I don't know enough about these statutes in general. I guess there's not a non-felonious taking of another's life. Representative Craigo?
I don't know the answer. All I know is that's the current statutory language. Obviously, it's in there, but how I would assume is exactly what you're describing is if we're going to end up in a trial, essentially you'd prove that it was a crime through a civil proceeding. I mean, that's how I would foresee that happening, is that and they're trying to exclude misdemeanor crimes. For instance, manslaughter, a potential, can be a felony, cannot be, just depends on the situations. So I think it's really honing in on the intentional act of murder rather than some accidental death or something that is in between.
Right, an accident, like I'm driving the vehicle with my wife and I wreck. Okay, all right. Senator Cooper?
I believe that part of what they did when saying that the slayer was predeceased addresses that, but I can find some advice on that and get back to the committee if that addresses the issue, and we can.
I think you're okay, Senator Cooper. We'll look it up. We'll be
Okay.
fine. It doesn't, just more of a curiosity on how that would play out.
Yeah. I don't have the answer to that, and that's not a question that I've heard so far. But I think it's a valid question and something that probably needs looked into.
Yeah, we'll definitely research it just in case our floor wants, and I know it's existing language, but our floor sometimes likes to ask questions about existing language.
Okay.
So the only other thing I will note then is when this went through the Senate, originally we were just dealing with types of joint ownership with survivorship. Key on page 2, you added in the will substitute portion, as I like to call it, which is the other death designations, beneficiaries, pay on deaths, things of that nature. And so I'm going to have an amendment that I'm bringing to my committee. And all it does is clarify your title now, because your title was about joint ownership. And now we've got the pay on deaths and beneficiaries in, which are not joint ownerships. So we're just going to amend your title so that it's broad enough to fit both of those categories.
That's very agreeable, sir.
Okay. Other questions for Senator Cooper? All right. Well, thank you for this bill, Senator Cooper, and your presentation.
Okay, thank you. If you're not in anything else, I'll go back to my other committee. So
You certainly may.
thank you very much.
All right. Clarissa, do we have anyone in the virtual world?
Mr. Chairman, we do. We have Sarah who has raised her hand. She has been admitted to the meeting.
All right, Sarah. Come on in.
Good morning. I apologize. Can you hear me?
Do you have a camera by chance?
I do have a camera. I am just less prepared than I was for the first time. So I'm actually at work. If you don't mind the video from the work office while I'm holding it. Otherwise, I can do that. Good morning, Honorable. I did listen before. I think I'll call you, Your Honor, as well. Your honors as well. That's easy for me.
We're going to need to get some robes and some wigs to make this really work. Go ahead, Sarah.
That would be great.
Yeah,
so
go ahead, introduce yourself.
I really appreciate the extra time today. I hadn't originally planned on testifying and letting it come to committee on the onus of everything that had happened before being presented. I did listen to the entire testimony.
Sarah, I got to pause you. Can you introduce yourself first name, last name, and then if you represent an organization, we need to know that on the record. Thank you.
Okay, I am very sorry. Yes, my name is Sarah Sevchek. I am not representing an organization at all. I am a personal friend of Deidre Rowe and her family, and they are, we are the ones who are struggling with the actual on the ground implications of how not having this bill in legislation is actually causing harm to Wyoming families. So that's more my perspective is certainly not from a legal background, but more so from what's actually happening. When the bill was brought forward to the Senate Judiciary Committee, my friend Erica Ketchum and I both testified in the same aspects, and Deidre's father was there to testify to talk about Deidre's life and her experience and how everything has happened after this terrible tragedy seems like such a soft word for how much her family's been through. And so it went through Senate, the Senate Judiciary Committee was passed with several amendments and went to the general Senate floor. I really respected and would like to echo what Representative Landon talked about as just bringing some clarity to the history of why it's needed. When it did get to the floor of the Senate, it was discussed, some of the elements of two amendments were actually brought forward that were ultimately turned down. One required a conviction, and one required what would be considered a coroner's finding. Both of those were defeated. And really, Senator Noricott, she is also a legal attorney, and she was our greatest legal advocate in that element, in that she was really able to clarify that this wording is to free up and untie the hands of the civil judges when they're hearing these cases. So for example, in Deidre's case, Deidre passed away on February 15th of 2020. And her husband did kill her. And then hours later, he killed himself. And they have been struggling legally because the court's hands, civil court's hands, are also tied in being able to, how do I want to say it? Again, I'm not a legal person, but being able to even discuss or represent her family, being able to represent the fact that they do have a police report that shows what happened and how it happened and how it wasn't a mutual decision. It wasn't something that was an accident. And being able to present that into the court, in the civil court, they've been met with every barrier. The attorneys for Darren's family have actually said that in cases of murder suicide, they will come out on top because there's no precedent for it. And so what they're struggling with is that Darren's family, and again, I would like to take that back. It's not an adversarial issue. I don't want to speak bad at all about Darren's family. They're struggling as well, and they lost their son. And this legislation would just allow a civil judge some clarity to say, no, we understand that it's written A, B, C. We would like to add D in the very specific cases that it's necessary, to allow them to review it and not give all of the benefits of life insurance to Darren's family or the house and the all the items. I think from a personal standpoint, all of her items, when we talk about items, it's not about money. The house is locked up. It's locked in the probate because the courts can't make a final decision. And so her parents don't even have her clothes or her jewelry that they gave her for graduation. They don't have her pictures. And I'm sorry, I was doing really, really, really good. Not crying. So I think my testimony simply would be the emotional impact that it has on victims' families. There's no winner at the end of cases like this. And so I do know that it was discussed in the Senate regarding, the clarification between what would be considered felonious or not. And I think that clarity then would provide the courts the ability to differentiate between whether someone took their life or it was an accident or something like that. And then allow a more speedy process to closing the probate or the estate, because there's no healing right now. We're still just thrust in this continual grieving process because we're fighting every day and they're fighting every day. I say we, but her parents are fighting every day. And I think that this is not a case, if you read or read up on this in Wyoming, it's very sad, but it's not as rare as you would think. And Deidre's family has really taken the fight to the court, so to speak. They have a passion to rectify this for other families in the future. We know that this isn't going to help their battle at all, probably. And so it's more so to help other families in the future not to have to carry on a legal battle for over a year when you can't present to a judge that someone took your daughter's life rather than them passing together. And so, as I said before, it's not about money. It's about providing the courts the ability and the clarity to assess those on their own, which is why Noricott was very instrumental in stating that if adding other language like requiring a conviction or requiring a coroner's decision, then adds another element of government and judicial requirements into what should be just a civil court matter. If I'm understanding everything that she said correctly. And so with that, I am the one that sent the email to you all yesterday with the article that did kind of highlight the testimony. It does have some more in-depth. Again, it was very emotional testimony, and that's really what we're advocating for personally is the change to protect for families in the future. And that's really what I wanted to say and clarify, as well as just show support and ensure we at least pass committee at this level. Okay, I think that's it. And I made it with very few tears. I don't know how that happened. But I do want to thank you all for your time. This process has been incredible and hard. And I just want to say thank you to you guys. I have no idea how you do this every day and get through this. It's amazing. I really appreciate the time and the effort that you all take on all of the matters that are important to our state. So I just wanted to add that at the end.
Sarah, thank you so much for sharing all of your personal story and thoughts with us. We know that's not easy, and so we definitely appreciate it, and it does help us, obviously, in making decisions and certainly in advocating for this bill.
Thank you. Is there any questions or anything that I can do, or should I just keep watching?
Committee, do you have any questions for Sarah? No questions. Thank you so much, Sarah.
Perfect. Thank you very much.
Enjoy the rest of your day.
You as well.
Clarissa, anyone else in the virtual world wishing to testify on this bill?
Mr. Chairman, I don't see anyone else with their hand raised.
All right. That being the case, we will close public comment. Committee, what is your pleasure?
Move the bill.
Moved by Representative Zwanser, seconded by Representative Crago. We have a couple of amendments. I just emailed everyone around another amendment. And Kay, I emailed it to you. So I know you probably not gonna have your email in front of you, but it's we got two different amendments. The one I just emailed to you has quite a bit of language. So I think it'll be easier that you have it in writing. So that's why I emailed it to you. And so the first one is really easy, committee. The First Amendment is the one you have printed in front of you. The First Amendment is simply just cleaning up the title. That's the one I mentioned to Senator Cooper. So after the good work on the Senate side, it broadened the bill beyond the title of the bill just a little bit. So we've got to LSO in reviewing it has suggested this change that I have in front of you, that we broaden the title to just Slayer rule amendments, and that way we don't have any constitutional issue with where the bill is at right now. So I'd ask for a motion on that amendment.
Mr. Chairman, so moved. Proposed amendment H1101.
Okay. And seconded by Representative Larson. Discussion on the amendment. All those in favor of the amendment signify by raise. Oh, you have discussion on the amendment? Oh, all those in favor, raise your hand. All those opposed? That amendment carries. Now the second amendment that I just emailed around, we're looking at page 2, subsection C, And this is really just a product of the discussion that we've been having on the predeceased issue. So this is as the bill moving through and as we're thinking more about the predeceased section, this is an attempt to try and tighten this up. I think if we leave it with the predeceased language, there's at least a question that we could run into some unintended consequences, and particularly an unconstitutional issue that could result. And mainly what we're looking at is property work, mineral work. And I think that the issue centers around theoretically what would happen under the laws written. You had an entire estate, 100% interest in the land, vesting. The key is vesting. So then when you sever that, you're taking away a vested property interest that somebody has. I'm not a constitutional law expert, but that could raise a constitutional question. So I think if all we're doing with this is inserting this language in front of subsection C, keeping the rest of subsection C, adding for purposes of any concurrent estate referenced in 2-14-101A2 above, any rights of survivorship accruing to the benefit of those person or persons identified in the statute shall be considered as being terminated prior to the death of the person whose life is taken. So all we're saying is that because there's a vested interest, we're going to clarify in law that we terminate it prior to the death, instead of saying they just predeceased and so it's really just a clarification as opposed to just saying predeceased. Where does that mean? As to the vested interests of the person whose life, prior to the death of the person whose life is taken. Okay. As to the vested interests of the person whose life is taken, and in every other. Okay, all right. So we got one more sentence to add to that. We're almost there. So we're going to add to the end of the amendment that you have in front of you in your email. I'm going to put a period after taken and add as to the vested interests of the person whose life is taken. And then we'll continue on with the rest of the sentence and in every instance mentioned in this section, and the rest of subsection C remains. So all we're doing is clarifying the termination of the vested interest, that it terminates prior to the death of the person whose life is taken.
So it doesn't have to go into a weird probate or legal proceeding then on the land. I mean, that's ultimate.
Yeah,
Save
well, at least
yourself from sorry.
Yep. Nope. Yep. Go ahead, Representative Zonser.
I'm just wanting to make sure I'm clear, Mr. Chairman. So then it wouldn't force the land into any kind of court action, or it wouldn't go to probate, depending if there's, I mean, I'm just trying to make sure you're basically saying it's terminated before their death, because if it was terminated upon their death or after their death, you would have a separate weird legal proceeding. I mean, that's the ultimate intention, right? To stop some type of further court action that would happen upon their death if it wasn't terminated prior to their death. It seems like a weird way to write a statute where you're taking out their right technically before they die, because we know they're going to. It seems like a very weird claim to me, I guess, is my concern, but I'll talk to some attorneys and get comfortable with it.
Yeah. So because typically in this area of law, what we like to see in our statute is the predeceased language shall be considered to have predeceased. So the slayer would be considered to have predeceased the victim. And so that's the typical language you would see here. I'd have to comb the statutes to see if this is, I don't think we do use this language. I think it is unique to be considered as being terminated prior to the death of the person whose life is taken. But ultimately, it really does say the same thing as if you had predeceased. But what it does is actually, I think what you were honing into, Representative Swanser, is that 50% interest. It deals, it's so that they would not have a right of action to the 50% concurrent interest of the victim.
That person's family. Okay. Yeah, it's jointly own a property and kill your spouse, and all of a sudden your heirs don't get, or your family doesn't get their half, and just because you did something stupid and that family's been on the ranch for 5 generations.
That's already what the bill is already doing, that, Representative Swanser. So among the other beneficiaries or heirs of the deceased person.
So what, Mr. Chairman, one is possessions, I would say, and maybe personal financials. Another is if I just think if you have a multi-generation ranch and family, and it does seem weird that, well, and yeah, and children, I just have a lot of concerns, but I think by the time it gets to the floor, I will talk to some attorneys and get comfortable with it. I just want to make sure we know what we're doing and it covers the right situations without unintended consequences when it comes to land, or perhaps even like mineral rights on that land, et cetera. You know, those get really interesting in Wyoming law. So just those concerns, but I'm comfortable with it to vote for it today.
Mr. Chairman, I understand the purpose of the amendment. I'm not sure I like the language. It's a little complicating to me. And obviously the person who drafted it is well versed in that area of the law. And so,
yeah, we probably haven't discussed that this amendment comes from a professor in property law,
right,
as opposed to a legal writer.
Right. And so that I'm just reading it, and I hadn't studied it before this morning. I have been sent it. In all honesty, I just hadn't had time to get to it. But as I sat here and read it this morning, I think we need to address that issue. I'm just not sure that's the right language exactly. That's my only concern. For instance, I mean, it says any person, to the benefit of those persons identified in 214-101A. Well, I mean, I understand we're talking about the quote unquote slayer, but the way that's written, it's not super helpful to me. I mean, as I read it as just a practitioner, I think we could clean that up a little bit. I don't disagree that we could do that. And I don't know how to do it sitting here. I'm be honest. This is out of my wheelhouse for sure. But I'm just saying, as I read it, I understand what we're trying to do. I'm just not sure that language is. I think we could maybe make it simpler and easier to read and accomplish the same purpose. That's all.
Mr. Chairman.
I see. So because when we look at subsection A, the only person referenced in subsection A is the actor, the slayer. No person who feloniously takes, but it seems like you're caught up on the life of another, and that could be the person that we could potentially be referencing to in subsection A. Okay, Representative Yin.
Mr. Chairman, I wonder if we could just move this as a conceptual amendment that also could clean up a lot more for us.
I like that idea. So conceptually, we know what we want. I think I want to make sure I understand concerns with the committee, because the only concern that I'm hearing right now is that we may be attaching to both the victim and the slayer, which could impact the heirs at law of the victim. And we don't want to impact the inheritance of, that's what I heard from Representative Zwanis. Representative Craig.
Mr. Chairman, I think actually it's the opposite. I think Representative Zwanitzer is worrying about the heirs at law of the slayer himself or herself, because what this bill says, you can't, if you're the slayer, you're not giving up what you own. You're giving up your right to inherit from the person you killed. Right? I mean, that's what this law does, and All we're really doing with this other language within the statute is saying law has changed over the years, and really what we're doing, if you read subpart little 1, let's look on page 2. The as written now, the law only applies to any portion of his estate. Well, as you know, Mr. Chairman, and anybody that practices in estate planning, most of our stuff doesn't go through our estate anymore. We use other mechanisms to keep everything out of our estate. We intentionally do that. And so what this is doing is widening that scope of what the law applies to, which we need to do. Like, I definitely think we need to support the bill. I think we're maybe complicating the issue. We're not trying to go after whatever property the slayer owns. He still or she still is going to own whatever they owned. Their half of the property is still their half of the property. I don't think we should try to change that. And if that's what that amendment's doing, then I won't support it. I don't think it is. When I read it, I didn't think that's what we were trying to do. But if it is, then I won't. I think that's probably taking us down a road I'm not willing to go down, at least not today, maybe some other day. But I thought we were just trying to expand the scope of what applies under the Slayer rule as written today.
So those are two. So you raised two very different things, and I definitely, okay. I think we all agree. I don't know that the goal of the bill is to go after the Slayer's existing property, but on the other point of the heirs of the Slayer. Okay, so the language that we have right now in the bill says that with using the predeceased language, so going from page 2 over to page 3. The heirs of the deceased person according to the will, trust, or other valid instrument, so a will or trust, person as those the person causing the death, so the slayer of the deceased person has predeceased the deceased person. So if the slayer is considered to be predeceased, we don't know the outcome for his heirs at law or her heirs at law, for the slayer's heirs at law, because we don't know what the instrument says. If the will, so the effect would be if the will or the trust says that we just don't know what the will or trust says. All that's saying is if let's say this is a married couple, the husband is considered to have died first. Then if the will says that if my husband is dead, I give everything to his children, then it still gives everything to his children. If the trust says that, it still will pass to his children. So that can't change because we don't know what the instrument says. If there is no instrument, if there is no will or there is no trust, intestacy law applies, the law of descent applies. And if the slayer is considered to have predeceased the wife, the only time there's likely an impact for inheritance is if it's a mixed family. If it's not a mixed family, they share the same kids, and by the law of descent, the kids would inherit his share. If he has children from a different marriage and she has children from a different marriage, and he's considered predeceased, then his share would pass to his heirs at law, and her share would pass to her heirs at law, unless the instrument, a will or a trust, says otherwise. So all of that, there's so many scenarios. Well, there's so many scenarios because it depends on if there's an instrument and what the instrument says. We're not impacting, this doesn't impact we don't know, we can't impact the inheritance of the slayer because we don't know what an instrument says or even if one's going to exist.
In any instrument that exists, and Mr. Chairman, so any instrument that existed, a will, a trust, would automatically come before. This would be in the situation where there's no other instrument that they could find at the time, that there was no other kind of trust document or will or anything else, then this applies. But as long as there is some other instrument that people have signed off on, the Slayer rule in general, it's just a new area of law for me. So I just know that there's a lot of, when I deal with the subdivision statutes and the ag statutes, on how families have done weird things on, it goes to your sibling before it goes to your spouse and it goes to their kid. And your last name has to be a certain thing on the bloodline. If you've adopted or you have stepkids, there are families in Teton County who have, it is great, when I've looked through some of these agreements. So I'm just making sure those would apply, but if somehow there's been no other instrument mentioned, then the Slayer rule comes into effect.
Yeah, the only scenario, I think when I read this, and maybe there's another one, but the real scenario that subsection C is going to address is that mixed family. So, husband has kids from a different marriage and wife didn't want, this happens all the time. Wife doesn't want her estate to go to those children. She wants it to go to her children, and there's no adoption. If an adoption doesn't occur, they're not the children as stepchildren. If there's no adoption, they don't take by inheritance. If there's no will or trust, that's the default law. That's called the law of descent. So in that scenario, husband has children, stepchildren were never adopted by mom. They don't get along. He's the slayer. Mom dies. He's cut off if he lives, right? He's cut off from inheritance. That's the purpose of the Slayer rule, right? That's what we're addressing. But what this subsection C would also do, without the amendment even, is say, and the stepchildren are cut off too, unless her will or trust specifically gave to them. Because if he's considered to have predeceased her and he doesn't have a will or a trust, the law of descent would give half of his estate to his wife and half of his estate to his surviving children, whether they are adult or children.
And she dies and her half goes somewhere else. So his half would go to the kids and her half, she doesn't have a will. She might have her own kids. She might have said, if I ever get killed by my husband, all my money goes to charity.
But in terms of the amendment, if we want to conceptualize the amendment, or I'm not married to the amendment. So if we want to conceptualize it, I think it's an issue that we have to address. The issue that we're trying to address is the constitutional issue of divesting a person of their interest that is vested. So you don't have a vested interest. Everything we've been talking about in wills and trusts, that's not a vested interest. That can be changed at any point in time. The vested interest is in the land records, where I have that vested interest. That's what we're trying to address.
Mr. Chairman, we did. I think Representative Yin made a friendly motion to the amendment that we're giving LSO latitude to conceptually ensure that the wording is sufficient. Is that, I just want to make sure the motion on the table would include that we'll explain to LSO our concerns and ensure they get it right.
Explicitly, I think we all agree that our objective is not to take away a surviving slayer's property.
Correct. All this money, yes.
Only inheritance rights to property, not his existing vested property rights. And that's what we're trying to address, is the existing vested property interests, not ones that he may stand to inherit. Right, Representative Crago?
And I think that's the intent of that amendment, actually. It just is not super clear to me. I mean, I think we could use a little bit different language so that we make sure who we're referencing in subpart A. I guess that was what we're trying to get at.
I'm there. I think we're there. Okay. All right.
Can I ask one more dumb question? I
ask
apologize. The Slayer rule only applies to married spouses. It doesn't apply to like a child killing their parent type of thing.
It does.
Oh, it
Sorry,
does.
we've been using, so if you just go up and look at page 2 real quick, when we're talking about the different types of tenancy that would apply, any joint tenancy with a right of survivorship, tenancy by entirety is husband and wife, or any other form of co-ownership with rights of survivorship. Representative Wanser, you and I could be joint tenants with a right of survivorship, and this would apply to us.
Anytime you want to do that negotiation, Mr. Chairman. Okay, so I just want to make sure, so there's nothing if it's a parent and a kid and the child killed their parents, then you'd consider their property rights. I just want to make sure those type of situations as well are covered, but I'm sure LSO will do that, and I would encourage support of the amendment. Quit talking.
This has been a mind-bending moment in the Slayer amendments.
Just a fascinating.
All right, all those in favor of the conceptual amendment signify by raising your hand. All those opposed, that amendment carries. I know it's confusing, Kay. We're confused too, but we know.
I'll get
So
together
the-
with somebody.
Yep. So ultimately for your notes on what we're looking at is page 2,
Okay,
line 18.
all right.
And at least for the purposes of your notes that we have right now, the amendment is to insert in subsection C on line 18 in front of in
Mhm.
a paragraph that I emailed you. So you'll have that in your email when you leave here.
This one. She brought
Yep, you
to
got
me.
it. Yep.
She brought this to me.
Yep.
Okay.
And you just, you insert that paragraph and
Okay.
then you lowercase the I and the rest of the paragraph remains
Lowercase.
in the existing language. So subsection C begins with in every instance.
Correct.
So that sentence remains. What you have in front of you, that email, you're just inserting it in front of in.
Okay.
And then I will get with LSO to try to make sure it works the way we want it to work.
All right, then the sentence at the end that Representative Oakley discussed, is that part of it or no?
I don't think Vice Chairman Washit knows that we haven't voted on this bill yet. Does someone want to grab him while I continue dialogue with Kay? Oh, really? Sorry, go ahead, Kay.
Then at the end, where Representative Oakley brought something up about taken and.
Mr. Chair, I think you read it in. or-
Yep, I'll get it to you.
Okay, all right, thank you. Okay,
Okay,
okay.
I'll get
thank
with you right after we vote.
Sounds good. Thank you.
That might be about 50. This firearm bill might have died over there.
He did leave a,
Oh, you did live a vote?
He
Okay.
left a vote,
Well, with that being the case, no other amendments on this bill. Kay, will you please call the roll on Senate File 66 Slayer Rule Amendments?
Representative Craigo.
Aye.
Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Williams.
Aye.
Vice Chairman Washut voted aye. Representative Yin.
Aye.
Representative Swanitzer.
Aye.
Chairman Olson.
Aye.
Mr. Chairman, you have 9 ayes.
Excellent. Thank you.
Mr. Chairman, we still scheduled for noon?
And those were the only 2 bills on our desk, so we will not have a noon meeting.
But you're welcome to the net metering and corporation.